खूप महत्वाचो. आमचे गोंयकार जे गोंयान आसा, भारतान आसा, तशेंच भायर सेटल जाल्या विथ पोर्चुगीज पासपोर्ट. खूबसो एक अनसर्टनिटी कसो एक माहोल हांगा तयार केल्लो आसा सरकारान. देर इज अ लॉट ऑफ डाउट इन द माइंड्स ऑफ द पीपल. आनी हे क्लियर करपाक लोकांचो जो हुस्को जाल्लो आसा, टू पुट दॅट एट रेस्ट, आयज आमचे बरोबर आसा एक रिनाउंड एडवोकेट आनी आमचो काँग्रेस लीडर एन MLA ऑफ आल्दोना कॉन्स्टिट्युएन्सी, एडवोकेट कार्लोस फेरेरा. आमचे बरोबर आसा प्रेसिडेंट GPCC बाब अमित पाटकर. आनी हो विशय दोतोर आतां तुमकां इन डिटेल एक्सप्लेन करतलो.
Good morning to all of you. आयचो विशय आहा तो कॅप्टनान सांगला त्या प्रमाणे तो अफेक्ट जाता कित्याक भरपूर लोकांचे पासपोर्ट आमचे इंडियन पासपोर्ट रिन्यू करूं येतात तेन्ना लोकांक त्रास जाता. ते पासपोर्ट रिवोकेशन जाता आनी थोड्यांचे दुवो आसा मनान सिटीजनशिपाचे आनी कॅन्सलेशन आनी सरेंडर आनी रिवोकेशन. पयले कायदो पडोंक जाय लोकांक, कित्याक एक पाटी कायदो मनान बसलो मागीर 2 पाटी 3 पाटी आनी ग्रुपान नाजाल्यार वॉट्सॅपान मागीर डिस्कशन उणी जातले आनी लोकांक एक्चुअली कितें तो कायदो कळटलो. पयले आमगे कायदो म्हणलो कॉन्स्टिट्युशन आनी कॉन्स्टिट्युशना प्रमाणे पार्ट 2 ऑफ द कॉन्स्टिट्युशन सिटीजनशिपाचेर उलयता. कोणा सिटीजनशीप मेळटा, कितको सिटीजनशीप एक्विजिशन करूं जाता, सगळें आसा थिंगा. पूण एक आसा इम्पॉर्टंट आर्टिकल 9, persons voluntarily acquiring citizenship of a foreign state not to be citizens of India. हें मातशें सामकें आयक. No person shall be a citizen of India by virtue of Article 5 or deemed to be a citizen of India by virtue of Article 6C or Article 8 if he has voluntarily acquired citizenship of any foreign state. म्हणल्यार कितें, द मोमेंट तुका तुजी सिटीजनशीप भायली फॉरेन स्टेटाची घेयली, यू सीज टू बी एन इंडियन नॅशनल. नाव दिस इज व्हेरी इम्पॉर्टंट. आर्ग्युमेंट हांव आयकतां, लोक सांगता की पासपोर्ट हाडलो ना, पासपोर्ट हांवें अप्लाय केलो ना. पळय हांवें रेजिस्टर केलें म्हजें बर्थ पुर्तुगालांत, पूण हांवें पासपोर्ट हाडना. पयलो प्रश्न, पासपोर्ट कितले इंडियन लोकांक पासपोर्ट ना, कित्याक ते भायर वचनात. पासपोर्ट इज ओनली अ ट्रॅव्हल डॉक्युमेंट. सो पासपोर्ट ना जाल्यार ते इंडियन न्ही म्हूण सांगूं जायना. दे डोंट लूज इंडियन सिटीजनशीप ऑर इंडियन आयडेंटिटी merely because they don't have a passport. So this is the first background you have to understand. Because passport is a travel document for international travel. So only at that time people apply for passport. Some apply and keep it. So the excuse of saying I don't have a passport will not hold any ground. Now the question is, no person shall be citizen of India. I'll just skip those articles. If he has voluntarily acquired citizenship of any foreign state. एक कायद्याने कितें म्हणलां, you acquire the foreign citizenship, you will not be an Indian citizen. In articleाचें म्हणलो ना that you have to voluntarily relinquish your Indian citizenship. Please understand two parts. That after you go there, you are voluntarily relinquishing. No, you are by fiction of law. The moment you have held a foreign citizenship, you cease to be an Indian national. This is the first thing you must understand. Magi Citizenship Act म्हणून आसा 1955. And थिंगा सांगतात how people can become citizens of India. Same thing what is provided in the Constitution. आणि दुसरी पासून आहात, even when we have area which is incorporated as a territory of India. Under section 7, it is there, if any territory becomes part of India, the central government may, by order notified in the official gazette, specify the persons who shall be citizens of India by reason of their connection with that territory, and those persons shall be citizens of India as from the date to be specified in the order. आमचे गोंय Daman and Diu Portuguese territory आशिल्ले before 19 December 1961. On becoming part of the Union of India, केंद्र सरकारान एक गोवा Daman and Diu Citizenship Order 1962 हाडला, and that is under this Section 7. In exercise of powers conferred by Section 7 of the Citizenship Act 1955, the central government hereby makes the following order, and this is called the Goa Daman and Diu Citizenship Order 1962. And Kit Boroila, every person who, either of whose parents or any of whose grandparents were born before the 20th day of December 1961 in the territories now comprised in the Union Territory of Goa, Daman and Diu shall be deemed to have become citizen of India on that day. मागीर एक प्रोविजो आहा, तुका नाका जाल्यार इंडियन सिटीजन जावपाक 30 दिसां भितर तुवें एक डेक्लेरेशन दिवपा जाय, I want to retain my original nationality or Portuguese nationality or whatever foreign nationality I have, and you make that declaration, you will not then become Indian citizen. तेन्ना हांव सांगता, हांवें आयकलां, I was born in 66, but I had heard what people told. The moment they went and made declaration, they were put into certain camps, waiting to be sent off to Portugal or wherever they had to go. So these were the people who were kept in those camps and they were sent. So the law is very clear. Under the Act, under Citizenship Act, all of us, people who were in India, in Goa, Daman and Diu, became Indian citizens by virtue of this order. Ata renunciation of citizen is provided in Section 8. If any citizen of India of full age and capacity makes a prescribed manner a declaration renouncing his Indian citizenship, the declaration shall be registered by the prescribed authority, and upon such registration, that person shall cease to be a citizen of India. My inquiry korpache and it done. Now there is another thing of a deprivation of Indian citizenship and termination. Termination is most important. Kita under Article 9 I wasla toka of the Constitution, if your citizenship is terminated by virtue of becoming a foreign citizen or I will come to the registration of the birth, by becoming a foreign citizen, the question is, suppose you don't relinquish your citizenship or you don't surrender, inga ek provision asa. Any citizen of India who by naturalization, registration or otherwise voluntarily acquires or has at any time between 26 January 1950 and the commencement of this Act voluntarily acquired the citizenship of another country, upon such acquisition or as the case may be, such commencement cease to be a citizen of India. I am repeating this. When he voluntarily acquires that citizen, he shall be a citizen of India. Exactly what Article 9 says. Why this is important? It is not when you relinquish, you cease to be an Indian citizen. It is when you have acquired that foreign citizenship, you cease to be an Indian citizen. Now, there is one proviso in time of war. They give you a travel certificate for purpose of traveling abroad, but that doesn't make you an Indian certificate. And this is what is given there. Suppose you're stuck today in one of the wars-ravaged countries, you're there and you're stuck, your passport is stolen, anything. That country may give you a travel certificate to travel, but that doesn't make you a citizen of that. That proviso hainga. Now, there's another part. In Section 9, subsection 2, if any question arises as to whether, when or how any citizen of India has acquired the citizenship of any other country, it shall be determined by such authority in such manner and in having regard to such rules of evidence as may be prescribed in this behalf. That means they have to conduct an inquiry and they have to take a decision by the prescribed authority. Now, prescribed authority is prescribed under the rules. Now, what is the prescribed authority? For that, it is Rule 40 under the citizenship rules. Now, there's a new rules of 2009 which has come into force. And under Rule 40, it says, authority to determine acquisition of citizenship of other country. For the purpose of subsection 2 of section 9, which I read for you, the central government may determine the issues as to whether, when or how any citizen of India had acquired the citizenship of another country. Adekita important. This first thing, central government is the authority. Let us make it clear. You have seen there are some orders which collectors were empowered.
Yes.
But the collectors were not actually empowered to decide under Rule 40. The collectors were like to collect the evidence and then submit a report to the central government. So be clear on this. Central government is not the authority under this act or the rules. They would have to submit a report to the central government, and on that the central government would have to hear that concerned person if the report is against him. If the report is not against him, there is no need of hearing, they should just decide. Or if the central government wishes to differ from the report and give a different report, they have to hear the aggrieved party, because you can't have hearing by one and a decision by another. Please remember this. The hearing is being conducted by collector and the decision by the central government is not possible. So this Supreme Court in 1962 Constitution bench has laid down, hearing by one and decision by another is invalid. So it offends the principles of natural justice. So it has to be by the central government and only central government alone. Now there is a Schedule 3 of these rules which provides the manner in which this exercise has to be carried out. Where it appears to the central government that a citizen of India has voluntarily acquired the citizenship of any country, it may require him to prove within such period as may be fixed by it in this behalf that he has not voluntarily acquired the citizenship of that country, and the burden of proving that he has not so acquired such citizenship shall be on him. A reverse burden of proof म्हणतात. हें कितें रिवर्स बर्डन? तांकां डॉक्युमेंट आसतले आनी ते डॉक्युमेंट तुका दिवपा जाय. हे डॉक्युमेंट आमकां आसा, आतां तूं प्रूफ कर की तूं सिटीजन ऑफ फॉरेन सिटीजन गेल ना म्हण. तो म्हणपा जाता, तेजें म्हणूं जाता, माय आयडेंटिटी वॉज स्टोलन, I don't know anything, I never made application. He could say it. The other thing is, he has to admit, or he must say, yes, this is me, I applied and I've done it. I have seen documents of certain people who have registered their births in Portugal, and when these issues came, the government of India had a complete record, including the biometrics done of those individuals, showing that eye scan, fingerprint, everything was done. So for that person afterwards to deny and say it was not mine would be difficult unless it is really not that person. So please understand this. Somebody else did in my name, somebody else, yes, it can happen, I'm not saying no. But if the other things tally that you appeared, you did it, then you're only going to dodge and cheat. You'll be ending up in problem. So this is reverse burden of proof. Of course, whatever documents they have to produce to that applicant, to that opponent, and they have to show him, we have these documents, what you have to say about it. You can't hide it. For the purpose of determining any question relating to the acquisition by an Indian citizen of the citizenship of any other country, the central government may make such reference as it thinks fit in respect to the question or of any matter relating thereto, to its embassy in that country, or to the government of that country, and act on any report or information received in persons of such reference. Mulole, I've seen that they write to the embassy writes to the government, to the registration department there, obtains all the documents, your complete file, and then submits it back. The fact that as an Indian citizen has obtained on any date a passport from the government of any other country shall be conclusive proof of his having voluntarily acquired the citizenship of that country before that date. As I mentioned, the moment you don't require a passport. But when you have a passport, it will be conclusive proof. This is what they say. This does not rule out that without a passport you can't be tried or you can't be. Now the question came, what about our Goans? That I will answer a little later. Now, as far as the law is concerned, on the Portuguese law, there are 3 relevant articles in that citizenship law, nationality law. Article 1C, I am reading. Portuguese by origin are the children of a Portuguese father or mother born abroad if they have their birth registered at the Portuguese civil registry or if they declare that they want to be Portuguese. Please understand, it's your father or mother who is Portuguese, and if they have their birth registered at the Portuguese civil registration or if they declare that they want to be Portuguese. From here, this is an attribution of nationality. This is the chapter under attribution nationality. The moment you register. Remember, our parents were born before 1961. The having born before 1961, they were definitely Portuguese citizens on that date. So if they were Portuguese citizens prior to 1961, they never voluntarily acquired citizenship of Portugal. But Government of India, by virtue of that order which I read for you, they conferred Indian citizenship on the Goans who were residing here at that time. Question may arise, what happens about those people? While you hold a Portuguese citizenship, you have imposed a Indian citizenship on them. Those people cannot be held guilty for that act today for having held a Portuguese passport at that time, even if they made no declaration to any effect under that citizenship order. The second article is Article 21, Sub-Article 3. Proof of nationality by origin. Now at Sub-Article 3. The nationality by origin of persons to whom sub-paragraph C of paragraph 1, Article 1 applies is proved, as the case may be, by the information contained in the birth registration made by the inscription in the Portuguese civil registry or by the registration of the declaration upon which the attribution depends. That means your proof of the nationality is proved by this registration or the inscription of your birth in Portugal. Do you see, this is very clear. Portuguese government itself is saying that the moment you register your birth in Portugal, you get all the attributes of a Portuguese citizen, and that can be proved simply by that registration of your birth. It comes back again. Where is the need of a passport? By this, again, that's why I said passport is a travel document. The law itself says that registration is enough. Now we come to Article 27 of the Portuguese Civil Code. If a person has two or more nationalities, among which the Portuguese nationality, only the latter is relevant regarding Portuguese law. Which means you can have an Indian nationality, you apply subsequently for Portuguese nationality, the last one which you get, that is relevant under Portuguese law. Which means the moment you acquire Portuguese nationality, by this registration, you become the Portuguese citizen and Portugal so recognizes you. Now there was, there was a lot of noise by the Indian diaspora that they are having difficulties, they have a connect with the land back home. There are many in the second generation, including first generation, who wanted to come back. In 1999, PIO scheme was introduced. In 2000, the Union of India, under the Ministry of External Affairs, under chairmanship of L.M. Sigmi, a high-level committee met on the issue of the demands of the Indian diaspora. And one of the recommendations made by them was for dual citizenship to PIOs of specified countries. Remember this? This was made way back in 2000. In 2003, the NDA government had introduced the OCI was introduced by Citizenship Amendment Act of 2003 for 16 countries excluding Pakistan and Bangladesh. Again the demand was there, why the 16, why not expanding? So 2005 they expanded it more for countries for OCI and PIO. And finally in 2015, by the Citizenship Amendment Act of 2015, PIO and OCI card was merged because it was creating confusion, and now we have an OCI card which is a singular one. आता प्रॉब्लम की झाला, in 2010 एक सर्क्युलर इश्यू केल्लो about time limit for surrender. पहिले time limit नाशिल्लो. So they started prescribing penalties. Within so much time you must surrender. If you surrender within so much time, you have certain higher penalties. So when this came, there was also the demand of the people by saying that you are being unreasonable in giving us a time. The cutoff date was being made as 2005 and 2010. Before that, people were applying for this PIO cards, and the law is what? The moment you get a foreign citizenship, you must surrender your Indian citizen. But the time limit was not prescribed for surrender. So, when the time limit was being specified and the penalty started getting imposed from 2010, then came the issue. Again, the issue was only in that table of the fees which were being charged, the penalties, so you could come to know what is the time frame. It is because of this conflict, this new circular came, OM came, Office Memorandum. But before that, I will explain one thing to you. There are cases where people are getting a cancellation, and there are people who are facing revocation of the passport. This is where the whole issue is burning now. First thing I've told you, that registration of the citizens of your birth automatically gives you a foreign citizenship. So that part is over. Now, there are people who after registering their birth still held the Indian passport. Some of them did not travel but kept it. Some for sentimental reasons wanted to still keep the passport. Some, after having the citizenship, foreign citizenship, still used Indian passport and traveled. There are other cases where people had foreign citizenship and applied for, sometimes got stuck or got caught, I would use this word, or even got their passport renewed despite having a foreign citizenship. It is in this last case where people have, after acquiring, they are not getting the cancellation but a revocation. This is where the problem is taking place. Also, those who did not surrender the passport within the 3 years, that's a 3-year time frame, whether you traveled or you didn't travel, the 3-year time frame which has expired, if you are not surrendered, they are also revoking it. So this is the problem which is being faced by our people. And now I will deal with that OM. This OM of 30th November 2022, MEA has sent it to all the passport officers. Ministry is in receipt of references from PIAs regarding surrender of Indian passport on account of acquisition of foreign nationality by an erstwhile Indian citizen. Cases of surrender certificate can be categorized as under 1. A person who acquires the Indian passport in the capacity of Indian citizen and approaches the nearest RPO mission post within 3 years of acquisition of foreign nationality for surrendering it, she does not use the Indian passport for travel after 3 months of grace period. This is the first part. Second part, again, where he has acquired the foreign citizenship, but he uses the Indian passport for travel after 3 months of the grace period. Third, a person who acquires the Indian passport in the capacity of Indian citizen and approaches the nearest so-and-so after 3 years, he does not use the Indian passport for travel even after the grace period of 3 months. And fourth, person who acquires the Indian passport in the capacity of Indian citizen and approaches nearest also after 3 years acquisition of one, he uses to travel the passport for travel after 3 months of grace period. And fifth, a person who gets Indian passport issued or reissued by suppressing material information about his or her having obtained foreign nationality, irrespective of the fact that the passport holder has used it for travel or not. So this is the last case. What they have said is, all these others, 1 to 4 on the top, you accept for their surrender. And in respect of cases under 5, the passports may be revoked by invoking section 10 of the Passport Act, since the passport was obtained by suppressing material information about their having acquired foreign nationality, and these holders were thus not eligible to obtain or apply for these passports. So you understand, a person who has genuinely come forward and surrendered his passport, I see that there is no difficulty except if the time limit has crossed. I think those people should also be protected, because the 3-year time limit, some people might have forgotten. There were cases where they have even referred earlier where people have misplaced their passports. So I think that kind of an extension should be given to the people. As far as people who have suppressed information, now the question would be, what should be done in those cases? Because the moment your suppression is there, you are misleading the authority, and that is why you are having it. What has happened is, if you remember 2014, there was Honorable former Revenue Minister, he was the Commissioner of NRI Affairs, Dr. Wilfred Menendez Mishkita. He himself wrote, as an NRI Commissioner, and that was when the NDA and the BJP were here. He says here, secondly, not every Goan born before liberation becomes a Portuguese citizen by default, and that his or her registration of birth in Portugal, as per the existing Portuguese laws, will entitle person to possess Cartão de Cidadão. And it is this document only, namely Cartão de Cidadão, which makes the applicant a Portuguese citizen. This clearly implies that the registration of birth is just the beginning of the process to obtain Portuguese citizenship through Cartão de Cidadão, and registration of the birth by itself in no way gives the applicant the right to be a Portuguese citizen. Now I will tell you with great respect, this is incorrect. But this is what NRA Commissioner was canvassing. This is what many of our Goans believed. When it comes from the mouth and on the letterhead of the NRI Commission, and it is sent to the Government of India, people believe it to be true. What sin have they committed if they believe that the government is supporting them on this stand? Everyone doesn't know these technicalities of the law. Especially look at it. Those who are working class, those people who want to go for better opportunities abroad, they have applied for and they believed registration, I have not become a citizen. Some have done registration, they are sitting here because they believe their children can get the benefit. And maybe they can get in some universities because there are scholarships when you are a European citizen. There are also entire European Union, you can travel without a passport, without a visa. All you require is your cartão de cidadão, your billet as you used to call it before. So therefore, this, I say that when this kind of thing was put in perspective, and the Government of India, that time Manohar Parrikar, who was the Chief Minister, had said he will get this issue resolved, and people believed it. I think the government should attempt to bring out these issues and have as a one-time measure. I remember in 2015 also there was an article where amnesty was sought for forgiving these people for the lapse which had taken place. Now recently, our Member of Parliament, Francisco Sardinia, wrote also a letter to our Honorable Home Minister Amit Shah, informing this situation, and also informing, correctly he put down the correct position, that people will be misled into believing that mere registration doesn't give them a citizenship. And this confusion has caused and causing now the tension for the people. So I know one thing, that we have Shashi Tharoor had done that.
June
Sir,
2019.
in June 2019, on the basis of the representation of a lot of people from Goa, our Honourable Member of Parliament, Shashi Tharoor, had tabled private members' bill to allow the dual citizenship so that people can get the benefit of the law and they can also get the benefit. See, I'll tell you one thing. Our Goans, especially our Goans, they don't want to go abroad, but they are forced to go because of circumstances. All feel they will come back, they want to come back. But if we start blocking people from coming, if we start making this kind of a situation by which we don't want them to come back, they will never come back and we will lose our Goans. And I think we should try to help our brothers and sisters. We definitely want to see all our friends, our relations, from wherever they may be. It is sometimes of a belief that large number of Catholics have taken Portuguese passport. I know for sure large number of non-Catholics also have taken. So it is not that easy to say that it belongs only to one particular community and does not affect another. Lot of youngsters also I know today who are non-Catholics who have also taken Portuguese passports, which means they have registered their parents' birth first and they have also now taken their thing and they are very happy about it. All of us are happy, but that does not mean that they should be put out of Goa or put out of the nation. So I think that I have made myself clear on these issues. If there is any query, you can please ask.
So what is the mere effect of registering births and you're not obtaining a Portuguese passport?
As I said to you, the Portuguese law recognizes that registration of the birth confers the nationality on such a person. And I mentioned passport is only a travel document. So not having a passport is not going to be the criteria to say that he has not acquired a foreign or Portuguese citizenship. So that will be the first part.
Then what about those who were born before 1962 who by virtue of their citizenship and this registration?
See, those who were born before 1962, as I said, were not, they voluntarily did not acquire, they were by birth Portuguese nationals. Till 2009, there was nothing about it. In 2009, when the new rules were brought in, of the citizenship rules, a complete new rules, first they were amending in parts and parts, there is one provision which was introduced. Now that is the provision which is going to cause problem for those people who had registered their birth prior. It says here, where a person who has become an Indian citizen by virtue of the Goa Demand and Due Citizenship Order or the Dadra and Nagar Haveli Citizenship Order 1962, issued under Section 7 of the Citizenship Act 1955, holds a passport issued by the government of any other country, the fact that he has not surrendered the said passport on or before 19 January 1963 shall be conclusive proof of his having voluntarily acquired the citizenship of that country before that date.
2009 कोणी केला
Central government.
कोणाची गव्हर्नमेंट आहे
See, the question is not whose government, it is the question is what is the law.
So what is the solution for
Wait, I'm coming to this. There are two parts of it. One is, you are born and you continue to renew your Portuguese passport. So this is tackling the situation of that pre-1961. And if you have not surrendered your passport on or before 19 January 1963. You understand? Now what, you can ask me a question, what about subsequent? There are people who were born before 1961, but they have gone and registered their birth now. Post 1961, they have gone and registered their birth. What happens on that? In my view, that is a conscious act on your part by which you are registering your birth, and therefore you are voluntarily acquiring the nationality of a foreign state.
And how do you react to a recent statement of President Harris, where he himself had mentioned that when he went and found out how his births were registered, and he himself had said that once you register birth, you officially become a Portuguese national.
Now, who said that?
Advocate Harris once he had officially informed that he has acquired a Portuguese passport.
By registration of the birth. That's what is my argument. I'm saying exactly that. See, only why I mentioned about that little inquiry be conducted. You might have heard recently in Gujarat, somebody was caught in Gujarat with a ID of a Goan, but a Gujarati travelling on that Goan name and on a passport, in the Portuguese passport. You understand? Portuguese passport, not an Indian passport. So was holding a Gujarati passport for India and a Portuguese passport in some other name, that too not even a Gujarati name. See, I can understand because a lot of Gujaratis were here from Daman and Diu. A lot of them are still settled here and they are there. Many of them may even be having Portuguese passports. Many have travelled. I have met many Gujaratis from Goa in Portugal and they are very happy over there. So they also would be eligible to get the passports. Understanding? So that is stealing of an identity, perhaps. I don't know how that lady had got that. And because it's not that she was born in what you call Daman or Diu. If she was, why you have to have one name in one passport and another name in another passport? There's no need. Here she had a Gujarati name and there she had a Catholic name. So it is completely at variance. So that's why I said, you can sometimes, as I mentioned sometime back in the last press conference, people are having this theft of identity by change of name and surname. And who knows, if someone using my name and surname goes and makes this passport, I can definitely say, that's not me, that biometrics is not mine, that whatever has been done is not me, and I can prove it successfully. So therefore, that is the second part of it. But the registration, simplicity in my view, automatically confers the foreign citizenship, and therefore there is no scope to argue to the contrary that I still continue with the Indian citizenship. We may continue with the passport.
हो जेन्ना इशू लोकां मुखार आयलो न्ही तेन्ना तुमचे जे कलीग आसा असेंब्ली कलीग एलेक्स सिगरांचे नांव खंय तरी आयलें सो त्या इशू कडेन कशें देवलें
ते डॉक्युमेंट पळोवन मागीर हांव कमेंट मारता. सद्या डॉक्युमेंट मागीर हाती ना. सो कितें जाता, everybody talks, everybody says, but for me to give you a correct opinion, let me see the document. I'll also tell you one more thing. थोडे भिवन surrender करतात. Surrender the nationality, the Portuguese nationality. Remember, by law, you don't get back your Indian nationality automatically. Because you may surrender and you may probably become citizen of United States, you may become citizen of Brazil, maybe you become citizen of New Zealand or Australia, we don't know. Why should it be that you're coming back into India? The cancellation doesn't get you back automatically. Which means you have to come back lawfully into India. You have to reside for that 7 years lawfully in India, and then you have to apply. And there's one more statement I want to make. This is a legal proposition which is backed by judgments. The grant or refusal of a citizenship is an administrative and executive act beyond the scope of judicial review, which means courts cannot even go into it. Why you were granted citizenship or why you were refused citizenship. Because there can be many secret matters, there can be friend relations, there can be internal issues which they cannot disclose in public domain.
There are situations where those born before 1961 continue to be Indian citizens, although they were earlier Portuguese, okay, with the citizenship or whatever. But their children want to acquire Portuguese citizenship. The parents don't want to acquire Portuguese. But without the parents' registration of the birth, the children cannot acquire Portuguese. What about that situation?
Actually, you are asking me how to acquire that Portuguese citizenship.
No, they have already acquired.
I'll tell you.
They have already acquired. They have already acquired.
I am not an agent for such matters, but I will tell you. I know of a family whose parents are very close to us for generations, for about 4 generations with my family. The parents have not applied, the parents have not registered. But this son went to Portugal. He was very brilliant. He has gone to America, then he has gone to Portugal. He resided in Portugal. He married a Portuguese, and he has acquired Portuguese citizenship.
No, that's not the point.
No. So the parents have not become.
The point of my question is this. People have already, those children have already acquired Portuguese citizenship by registering the parents' birth without the parents wanting to.
Can't be. You cannot simply take the documents of your parents and register them unless they are dead. Because they have to go and say, we want to become. You have to make a declaration there. Please understand that. You make a declaration, you take an oath that you are a citizen of Portugal.
Doctor, how many Portuguese passports have been acquired by such a method without the parents knowing? How many?
I don't believe.
Hundreds.
I don't believe.
Hundreds and hundreds. Those are the people who are in trouble with this.
I don't believe. If you believe that it has been done by fraud, then the parents should
Exactly, that's
set
the
it up.
problem. Mostly it is done by fraud, and then since it is your own child, you don't want to proceed criminally. That's the problem. That is the
See, this
predicament
is
at the
no.
moment.
This is the bogey which is sought to be made by saying that
It's not a bogey.
it is done by
It's okay.
somebody in. Because I told you there's biometrics done. How can those biometrics be skipped? Earlier there was no biometrics. I know long back,
There was
long
no
back
biometrics
situation
come
was
only
different.
recently. Biometrics is come only recently.
So doctor, now what is the solution for these people to save as a, they should get back to this thing? Is the 12 passport is a solution or?
No, I didn't understand your question.
No, to save these people whose birth is registered in Portugal and they are losing now the Indian citizenship. To save these people, not to lose the Indian citizenship, what is the solution now? To get a dual citizenship or some others?
See, I think the government of India first has to issue immediately a stopgap measure by which they protect these people who have already got the registration. Because the registration automatically you cease to be an Indian national. Second part would be to bring an amendment to the Citizenship Act to allow them an option to retain one or the other within certain time frame. See, citizenship, dual citizenship has a lot of ramifications, and I'll tell you why. It has not only cross nation implication, even financials have to be looked in, taxation, everything has to be looked in. So, and it's very difficult for the government of India to immediately say yes on the drop of a hat. But we will have to push forward to the government of India, because it's not just, let us be honest, it's not going to be just Portuguese people who have applied for Portugal from Goa. There will be people from Daman and Diu also have done it.
सर आता दोन सायटीचे ड्युअल सिटीजन जर दिले जाल्यार दोनूय कंट्रीचे बेनिफिट घेवपाक मेळटले
See, restriction करून जाता.
बेनिफिट म्हणटा हांव
Today, the government of India has opened up OCI card scheme by amendment. आणि कित करून जाता under that OCI card, they have specified. They have also specified what you cannot do. Like you can't contest local elections. Or you cannot participate in these kind of activities. कायद्यानो आसा.
So if the government wants, the government can do anything.
See, I believe that we will definitely request the government of Goa to pursue with the government of India. And we speak of double engine, so definitely we expect that the government of Goa will try to get a good resolution with the government of India, so that it can help and benefit our people, especially our people, who otherwise will be left in the lurch.
तर तुम्ही ओसीआयचे उलयले न्ही सो तेच हें जालें की जर हे अशें जालें ते आतां गोवन्सा वांगडा जाता जाल्यार ते ओसीआय घेवपा खातीर
ना की जाता सरेंडर केल्यार तुका OCI कार्ड मेळटा. तूं रेवोकेशन केलें जाल्यार तुका OCI कार्डूय मेळना. आनी फुडें लोक कितें सांगता विजाय पासून दिनात म्हणून येवपा आमगे गोंयकार मोडटले काबार थिंगा. सगळे उमेद आहा येवपाक क्रिसमस ना गोणसा नाल्यार दिवाळी येवपाक आनी सेलिब्रेट करपाक न्ही.
I'll just add last जे आमचे ॲडव्होकेट कार्लोसन क्लॅरिफाय केला रिगार्डिंग इंट्रोडक्शन ऑफ अ प्रायव्हेट मेंबर्स बिल इन जून 2019. गोंयच्या आवाजान एक representation दिल्ले टू द काँग्रेस पार्टी when Mr. Rahul Gandhi had come here on 10th of March 2019. And that private members bill was moved by Dr. Shashi Tharoor. आता ते तर अनकॉन्स्टिट्युशन आशिल्ले आनी ते बिल इंट्रोड्यूसूच करून दिवपाचें न्ही. The very fact they allowed and it went through, that means it was correct. फुडें व्हरोन दिवंक ना, discussion is a different matter. So as he said, I think so we'll push for it.